Hi, I'm Michael Sandler with Fisher-Sandler, and this is video number 3 in our Myth Busters series of videos. Video number 2 is talking to you about how you don't have to lose your house by filing bankruptcy. I'm going to talk about losing other property, namely cars and other things like household goods. A lot of people are worried about their car, particularly if they're filing a Chapter 7. The most common thing I hear is, I don't want to include my car, I needed to get to work. I can't lose my car. Well, first of all, when you file bankruptcy, you can't pick and choose what assets and debts you include. You have to list everything. You're going to be saying under oath that you've listed everything. So we have to list your car as an asset, and we have to list your car loan as a debt. So is there a problem keeping the car? Well, about a month after the case is filed, there's a meeting with a court official called a trustee. And the trustee's job, again, is to see if he can take any of your stuff, to sell it, and pay your creditors. Now, that happening is very rare. It's maybe 1 out of 20 cases. And it's usually a situation where someone has a house with a lot of equity or a business or something like that. A car, if you have a car loan on it, is almost always upside down. In other words, you owe more on the car than what it's worth. In addition to that, you get an exemption for $6,000 for a car that you own, meaning that you can have $6,000 in equity that you can protect. So if you have a car, let's say a 2014 car, and it's worth about $5,000, and you're worried about losing it, well, we have that $6,000 car exemption. And on top of that, you have a wild card exemption for $5,000 you can use for whatever you want. So you can stack it on top of that exemption if your car is worth $10,000, or if you have a second vehicle. I haven't seen anyone lose a car in a bankruptcy case probably in 10 years. It does not happen much. And frankly, trustees just aren't interested in your 10-year-old Toyota Corolla. The only time they're interested in a car is if it's newer and for some reason it's paid off. Like maybe you took a home equity loan out on your house because you wanted to pay off your car. You want to get rid of your car payment. Then we could have a problem, because then you might have a car, that's worth $20,000 with no loan against it. Then you can have an issue. But generally speaking, cars are not at risk when you file a Chapter 7 case. Now, if you just purchase the car, you do want to make sure that the lien is on it. And what that means is that after you buy a car, whoever the lender is supposed to file proper paperwork with the DMV to make sure that the lien is registered against that car. Some trustees ask that you get the DMV transcript from the Department of Motor Vehicles showing that lien has, in fact, attached to the car. So if you have a chance to go to dmvnow.com and look that information up for yourself by getting a vehicle transcript or stopping by the DMV, then you can be sure the loan has indeed attached to the car. If we're filing a case for you in the Richmond division, meaning Spotsylvania or County South, then the trustees actually require that DMV transcript. So that's something you should think about getting before we file your case. If you have any other questions about cars or other property, feel free to shoot me an email or give me a call. Hi, this is Michael Sandler with Fisher-Sandler, answering your quick bankruptcy questions with quick answers. So one question that comes up from time to